Welcome to Atlanta Business and Commercial Real Estate Law Podcast.
Hey everyone, welcome into the first episode of the Atlanta Business and Commercial Real Estate Law Podcast, where we give Georgia business owners and investors the legal insights they need to make smart decisions. I'm your host, Mike Leon. Today's episode, I'm joined by attorney Mark Battleson of Battleson Law, LLC, and we're going to be diving into one of the most important documents a business is going to ever sign, and that's the commercial lease of their property. Mark, it's good to see you as always. So now I imagine that a lot of business owners, they sign a commercial lease sometimes and they don't fully understand it. So what's the first thing you would advise them that they should be looking for before signing that document?
Thanks, Mike. So I think people really need to understand this is a business document, and it actually integrates directly into your business, especially if you're retail or even just an office space or whatever else. But, I guess on a high level, it'd be a matter of potentially getting a tenant rep broker to help you with your search and make sure something's appropriate for you, making sure that it's properly zoned and is going to actually physically work for your business, making sure that in the letter of intent stage that you're truly understanding what it is that you're negotiating, because that is where you get to negotiate the business terms. And then ultimately a formal lease gets drafted, which has all the nitty gritty details and all the gotchas associated with defaulting on a lease and the consequences of that, including maybe personal liability under a guarantee. So I like to get involved as early as possible in the process because I've got a lot of experience. I used to work for developers. I've been a developer of both retail and office, and getting involved when you're dealing with the business terms in the letter of intent phase. A lot of issues need to be negotiated then. Otherwise, it's considered to be a retrade of the business terms when you do get into the full lease negotiation phase.
Yeah. So, Mark, let me ask you, how does that differ, especially in the state of Georgia, the commercial lease laws? How do they differ from the residential leases? And explain why that matters for these business owners out there that are paying attention.
Yeah, I mean, in reality, the concept is the same. The consequence is the same. If you don't pay, you can get evicted. Commercial leases, though, it's when businesses are negotiating, there is essentially no consumer protection because it is considered to be an arm's length transaction between two businesses, regardless of whether you're an LLC, a corporation, or just a mom and pop sole proprietorship. The consequences can be severe, and especially there will be personal guarantees. Even if you have an LLC, unless you have a corporate balance sheet and a long-lived business that's been around for 5, 10, 20 years that can show consistency in cash flow and income, there's almost assuredly going to be a personal guarantee associated with any commercial lease. So yes, you have LLC protection from third-party liability, but when you're in a direct contract with a landlord, that's called privity of contract, and that landlord is going to require the personal guarantee of the key principles of the business in order to make sure that you don't bankrupt out or just close down an LLC and leave it without assets. They want a warm body and a beating heart that they can go after so they can track you down if you do default on the lease.
So, Mark, let me piggyback on that. What are some other common maybe clauses in commercial leases that often get overlooked and they can create problems down the line if the business owner doesn't spot these?
Yeah, I mean, essentially, look, everything you do under a commercial lease, you really need to understand it. I mean, while a lawyer can, negotiate the gotchas, negotiate the business terms, ultimately, it's a living, breathing document that you need to make sure that you are hitting your deadlines on making payments. I always try to negotiate in notice and cure provisions so that there aren't, if a payment just doesn't get delivered, even if you had made it, you want to make sure that you aren't going to go into an automatic default. You want to have an opportunity to cure an honest mistake. And, again, guarantee provisions, the commencement date. I mean, so I guess just, a lease has a timeline. You got a letter of intent, and then you're going to have to build out the space almost assuredly, unless it just happens to be pristine, completely built out by the landlord already, and you're coming right in with no tenant improvements or landlord's work. Those are defined terms within the lease. And you're going to have expenses associated with that, as well as construction, et cetera. So really, negotiating the lease is all about making sure that the lawyer understands what the tenant is going to need to do in order to get open and making money, whether that's operating as an office, operating as retail, which is I do a lot of restaurants and other retail businesses, in some industrial, but ultimately there's a timeline of signing a lease as the effective date. Then there's a commencement date of the lease. Then there's a rent commencement date of the lease, and usually there may be even some abatement of rent, which is free rent, while the business gets ramped up. All during that time, there may be construction going on either by the landlord or the tenant, and you need to make sure that everything is timed out right. So that's really just the timing component. But I could go on for hours on each component of it. But you really do need to just understand what your business is, what you're trying to achieve, and maintaining timelines, because those timelines and payments are the big thing in a lease.
Yeah. Well, let's expand on the payments part of this, because it is a podcast. People want to learn about this, right? So how can business owners spot sometimes maybe hidden costs, let's say like maintenance fees or CAM charges, and explain to the audience what is CAM charges?
Yeah. So typically in almost every lease these days, especially with what's called an institutional owner, they're going to basically want to pass through all the operating expenses of a piece of commercial real estate in what's called a triple net lease. So a gross lease would be you're just paying one amount of rent, and that would include all of the operating expenses. Those are pretty rare these days. Over the last 20, 30 years, everything's evolved into triple net because it de-risks the property ownership from the landlord's perspective, to where they don't have to worry about cost variability on operating expense. So a lease is going to end up having base rent, which is a price per square foot that you will be paying on that. And it's usually quoted as an annual price per square foot. Sometimes people quote it monthly, and then obviously you just multiply it by 12. But on top of that, then the triple net part of it, it'll be an NNN, triple net. And that is operating expense, taxes, real estate taxes, and insurance. And that is paid for by the landlord. And then they ultimately pass those expenses on a pro rata basis if it's a multi-tenant building. So if you're in a shopping center or an office and you are 1/10 of the leased space in that or leasable space in that building or premises, then you're going to be responsible for 1/10 of the operating expense and taxes and insurance of that building. And those are paid as what's called additional rent. And so back to your, I guess, finishing up quickly on your question of gotchas. So these are pretty obvious expenses generally, but common area maintenance is the broad one for just the day-to-day operating expense of a premises. And then there's electricity and things like that. The gotchas come from when they try to flat rate you on that, and then try to say that there's going to be escalators in this over the years, for inflation protection on their part. Usually it's supposed to be just a straight pass through, and you want to have the ability to audit that if possible. It helps keep the landlord honest. But I've seen some landlords, they end up trying to make it more opaque, which means you can't see through clearly and it's not transparent. And sometimes there's floors on it, and it can turn into a profit center. Landlords now are adding administrative expenses associated with this, which is semi-legitimate, albeit each thing that they add on, it's going as a profit center to them, or at least it can be. And you want to make sure you're keeping them honest. And I guess the last one I would be very careful about is what are called capital expenditures versus just an operating expense. If the building needs a new roof, okay, that maybe needs to be fixed by the landlord, and that is a depreciable expense. But it should be what's called amortized. That expense should be amortized over the useful life of that 10 or 20-year roof. And it shouldn't all be jammed in as one expense in 1 year, because if you've only got 1 year remaining on your lease, you're not going to benefit from the next 19 years of that roof, right? So that should be divided by the useful number, years of useful life, and then that would be amortized over that useful life. on a pro rata basis. You're paying 1/10 of 1/20th or something like that.
Right. Mark, let me ask you, because you just mentioned escalation within that answer. So what else should tenants know about the lease terms related to, typical leases have rent increases, right, year over year. So what should they know about lease terms related to rent increases or even escalation clauses, like you mentioned? Expand a little further on that.
Yeah, so the base rent is pretty easy to protect yourself on. I mean, certainly it's a negotiated item. Landlords have, historically until 2021, 2022, we were in a very low rate environment and a low inflation environment. And then, in the first couple of years of the Biden administration and the Federal Reserve, uh, they pumped money into the system, and inflation went, up to 9-10%. And so landlords started tacking on, rent escalations of 3, 4, and then 5% as they tried to protect themselves against the long-term increases in their cost of capital for when they buy the property, because they have an interest rate on any loans that they've got on it, as well as needing to protect themselves against operating expense escalation. So base rent will typically have a 3 to 4% escalator as industry standard on the base rent each year, and then there's an inherent inflation built into the operating expense of the triple net component that we were talking about. Common area maintenance, taxes can go up, and within that additional rent under the triple net component for common area maintenance, taxes, and insurance, some expenses are controllable, some are not. If the taxing authority raises your taxes as a real estate owner, you got to pay that or appeal it. And and then insurance costs go up. There's a minimum insurance that they're going to need to have a requirement on, maybe from their lender or just good business practices. And if those rates go up, those are kind of uncontrollable expenses, albeit you should shop it around and negotiate it. So putting a cap on your additional rent, on the triple net portion of it, may be possible. Most landlords don't like doing it because then it puts them at risk. But I've seen landlords, and I'm in the middle of one right now, where a landlord, my guy signed a lease, and the tax, and it was stated in good faith that the taxes and insurance and common area maintenance are going to be X dollars. Well, it turned out they forgot to add in the doubling of the tax rate in that, and the cost went up 40% on my client, which was material. It was tens of thousands of dollars a year. And so now we're fighting about it right now because it wasn't disclosed. The landlord knew about it. And yes, the condition, and I didn't negotiate the lease. I came in on the aftermath. And the price went up materially, tens of thousands of dollars. And now we're fighting about it because the landlord made a statement that it was a good faith estimate, and it clearly wasn't, because the landlord knew that the taxes were higher and they just screwed up and forgot to disclose it.
Yeah. So, Mark, in those type of scenarios, and again, without getting into specifics of that story, but what red flags should go off for business owners where the lease agreement is drafted by the landlord and there is, let's say, no legal representation? What should they be watching for with those type of agreements?
Well, self-servingly, I'll tell you, hire a lawyer. Obviously that's my business, but honestly, these things are mind-numbingly boring documents to read. They're super technical. People think that they can just sign. They get a letter of intent. They think they understand that, and if it's even a letter of intent can be pretty complex, depending on how it's drafted. But the hyper technical aspect of the timing issues, the default issues, the calculating of rent, both for the additional rent in particular, for the operating expenses, and these landlords, I mean, look, they're in the business of profit. They are looking to and most of them aren't looking to. They are drafting that document to benefit themselves. And the whole point of hiring an attorney is to, first and foremost, I cannot emphasize this enough, it's better to get your lawyer involved on the letter of intent phase and not just rely on a broker, even if it's a tenant rep broker, to negotiate the letter of intent. A lot of tenant rep brokers believe that they are in a good position to negotiate, but I see it repeatedly. There are opportunities to get better business terms which again are difficult to retrade on if you've already signed the letter of intent. To materially change something in a letter of intent, when you then get to the lease phase, it's just a lot harder, and there's a lot of pushback. So, but long story short is every single condition in this lease is drafted from the perspective of the lawyer, the landlord's advantage. And my job is to push back to what is kind of an industry standard and acceptable set of terms that help protect my client on a reasonable basis, not to try to kill the deal, but just to protect the client for both defaults and what they are supposed to get from the landlord, potentially in the form of tenant improvement allowance, which is cash, to the or abatements of rent, et cetera. So I more than pay for myself. I'm in almost every lease by virtue of the things I can save as well as de-risk.
Right. So, Mark, for someone that's listening to this episode right now, they're about to sign their first commercial lease. What's one piece of advice you wish every business owner would follow?
Honestly, just know who you're dealing with, and even if you don't know the landlord per se, again, this landlord is there for the purpose of profit. They aren't necessarily dishonest. And if they're professionals, they want a healthy tenant, but you need to read every single word in that lease, because every single paragraph in that lease, other than just, even the boilerplate, has, choice of law, and most certainly the personal guarantee. If you are signing a lease that is $5,000 a month for 5 years, you can do the math on that. That's $60,000 a year, probably plus another 15 in additional rent. 75,000 times 5 years, you're $400,000 or more of lease liability, plus the construction costs, plus your startup costs or relocation costs, and you're taking on a huge liability. And spending a little bit of money to do it right will save you headaches and possibly save you quite a bit of money, and certainly de-risk it for you.
Yeah. Mark, thank you so much for the time and the insights explaining all this. I truly appreciate it.
Yep. Thank you.
And that's it for today's episode of Atlanta Business and Commercial Real Estate Law Podcast. So thank you again to Mark Battleson for breaking down everything. If you want to get more information, you want to connect with Mark and the team, do me a favor, visit battlesonlaw.com. Don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.